Welcome. It's my pleasure to welcome you to the Mayor Brown series on dealing with the coming surge in law enforcement. Today's program focuses on global corruption and the FCPA, particularly the coordination of various enforcement agencies around the world together, which is an old trend, and new developments coming out of the Biden administration relating to a convergence of corruption, money laundering, and national security policy. I am the co-lead of Mayor Brown's global anti-corruption practice, and it's my pleasure to introduce my colleagues who will be joining me in this presentation. First, Jason Lindner, who's a former prosecutor out of the fraud section, has a well-established white-collar practice. I had the pleasure of working with him when he was in the Department of Justice, and he's certainly a familiar and well-known person at the DOJ. Gina Poliveccio is the former prosecutor from the Eastern District of New York. The Eastern District of New York is at the spearhead of the resurgence in money laundering prosecutions, starting back with the Fifa prosecutions. She's very familiar with every aspect of those developments, and she works out of our New York office. Michelle Sienkovsky is out of our Brazilian office. Why Brazil? When you look at the studies, they show that there are three countries which lead the world in terms of deferred prosecution agreements. Brazil is one, the United States is another, and the third is France, which brings us to Nicolette Costa Service, who is a partner out of the Paris office, who heads our compliance and regulatory investigations team, and is very well versed not only in the regulatory developments, but in the key leading cases in the anti-corruption area that have come out of Europe. Before I begin, I'd like to cover a few administrative matters that are of some importance. First, if you have any questions, I invite you to let us know via a Q&A function at the bottom of your screen, where you can type in the questions. We'll do our best to answer the questions today, and if not, we will follow up. As to the all-important issue of CLE credit, we will provide the obligatory alphanumeric code during the presentation. In order to receive the credit, participants must record this code on the virtual sign-in sheet that was emailed to you as part of the login instructions for today's program. Please return the form within 10 days by either scanning or taking photos of the form and emailing copies to cle-events@mayorbrown.com or faxing the form to 1-312-701-7711. With that, let's begin the program.
Thank you, Larry. I'll begin. May I have the next slide, please? Maybe one more slide after that. Perfect, thank you. So good morning and good afternoon, wherever you are in the world, everyone. As Larry mentioned, I'm Jason Lindner. I'm his co-chair of the firm's global anti-corruption and FCPA practice. And I spent 10 years at the Department of Justice, including more than half that time investigating and prosecuting almost solely FCPA and related money laundering cases. In the last, I'm going to be covering the US side of these developments. In the last 6 months or so, there have been 3 policy pronouncements that together have the potential to reshape the way that the government investigates domestic and cross-border white-collar matters, particularly FCPA cases. Before I begin delving into those 3 sets of policy pronouncements, let me just first briefly set the table of what the landscape has looked like over the last 10 years or so by white-collar enforcement. There have been 4 trends during the last 10 years or so that in combination have the effect of increasing companies' risks of undergoing an enforcement action and increasing their compliance burdens. One is increased international coordination, as Larry alluded to. The US is no longer alone in its fight against corruption, but has partnered very effectively with Brazil and France, where Michelle and Nicolette are practicing, as well as dozens of other countries around the world. They have coordinated, the Department of Justice and the SEC have coordinated very effectively with a number of other domestic agencies in making corruption-related cases. Most recently, the CFTC had its first resolution about 1.5 years ago, and public reports are that it's about to have its second in combination with DOJ and the SEC. The third is increasingly ratcheted up cooperation demands and opportunities for cooperation of companies. And the fourth is increasingly sophisticated compliance demands. For almost all of those activities, the DOJ's FCPA unit and the SEC's FCPA unit have led the charge, and either informally or formally through auspices like the OECD have been the primary players for the US government on the international stage. The first of the 3 policy pronouncements that we'll discuss today from the US side is that in June of 2021, the Biden White House announced that it would be taking a fundamentally different approach to anti-corruption enforcement that systematizes and ties together the threads that had existed informally and regrounds them across the entire executive branch. That policy pronouncement in June was followed by the promulgation in December of the United States' first ever formal strategy on countering corruption. May I have the next slide, please? Thank you. Oops, sorry. Yes, that's what I want. So that strategy that was promulgated in December has 5 pillars. I apologize, by the way, I am on an iPad in East Africa and I can't see anything all that well. So I'm doing the best I can with the PowerPoint. So the policy that was promulgated in December has 5 pillars, and there's a long document with a lot of detail, but very briefly, the first of those pillars is what they say, modernizing, coordinating, and resourcing the US government efforts to better fight corruption. What that means in practice is that it is no longer the Department of Justice and the SEC, but there are new anti-corruption task forces in the State Department, the Commerce Department, the USAID, and a number of other departments that are going to focus on anti-corruption. And there is an executive branch-wide steering committee that will harness them all together. That also means better coordination and information sharing between law enforcement agencies and the intelligence community, and a number of other facets of the executive branch and across the government. The second is curbing illicit finance. And I think that in part, Gina will speak about this more in a moment, but essentially it is to make money laundering harder for the beneficiaries of corruption through activities such as making more transparent beneficial ownership of entities, and focusing on gatekeepers that are involved in transactions where money might be laundered, accountants and lawyers and the like. The third pillar of the strategy is to hold corrupt actors accountable. So that means 2 things. One, that means continued and sort of stepped up enforcement of money laundering and related statutes against the demand side of the bribery curve, the officials abroad who receive bribes. And the second is seeking new legislation that, unlike the FCPA, can directly make criminal those who receive bribes abroad. The fourth pillar is preserving and strengthening the multilateral anti-corruption architecture. So that's the OECD, the UN's Convention Against Corruption, and other sort of formal diplomatic and international coordinating activities in which the US government will continue to be involved and will step up its activity. And the fifth and final pillar of this December strategy is in what they call improving diplomatic engagement and leveraging foreign assistance resources to advance policy goals. What that means is continuing to elevate anti-corruption as a diplomatic priority, continuing to assist our foreign counterparts in standing up and resourcing appropriately their anti-corruption law enforcement and investigative agencies, and in continuing to help them make cases. May I have the next slide, please? The second, I at least don't see it advancing on my screen. If I could have the next slide, that would be, oh, there we are. I think it is there. Sorry, thank you. The second policy pronouncement came in October of last year, so 4 or 5 months ago, when Deputy Attorney General Lisa Monaco addressed the ABA White Collar Crime Conference. And she announced a number of substantial changes to the department's corporate crime enforcement policies. One of the changes she announced would be increased scrutiny of companies that were currently in the middle of deferred prosecution and non-prosecution agreements. And that announcement was quickly followed by announcements that a number of companies were found to be in breach of said agreements, that there would be a new department-wide advisory group that would not just be individual white-collar components, the antitrust division, the tax division, the fraud section, off on doing their own thing, but a whole department white-collar advisory group to share best practices and coordinate. And then the next three policy announcements were all tweaks that had the effect of making corporate investigations more burdensome and potentially more costly for companies. One was a return to what's called the Gates memo, a requirement that companies that are under investigation to receive any cooperation credit turn over information about all individuals, not just those substantially involved, all individuals who might be involved in corporate criminal wrongdoing. The second is a broadening of the lens of corporate recidivism. So it had been the case under the Justice Manual that governed the way that the Department of Justice approached fashioning resolutions for companies that were found to be in violation of the criminal laws, that one of the considerations was whether a company was a recidivist. And the only thing the department looked at is whether they had, let's say it was an FCPA violation, whether they had engaged in corruption in the past and had been held criminally responsible for it. Now, under the new policy that Deputy Attorney General Monaco has announced, there are two ways in which that is broader and more burdensome. One is that the companies will be held accountable and need to disclose all of their past misconduct of any kind. So not just like-kinded conduct, but any conduct. And two, it isn't just criminal resolutions, it's civil and administrative and regulatory violations anywhere in the world of any kind. The final change that Deputy Attorney General Monaco announced in October was a reversion to the prior state of play before the Trump administration on the imposition of monitorships. So there was a pronouncement at the outset of the Trump administration that had the effect of making monitors substantially less likely to be imposed. And indeed, during the Trump administration, there were a number of very substantial corporate resolutions that might ordinarily in the past have been accompanied by monitors and were not. And after Deputy Attorney General Monaco's pronouncement, there have been a number of resolutions announced in which monitors have been imposed. And we know from our work here at Mayor Brown that there are a number more in the pipeline that are coming that will have monitors included in the resolution. May I have the next slide, please? The final policy pronouncement that's come in the last 6 months that augurs a real change and an increased burden in white-collar criminal enforcement for companies is the surge, the additional focus of resources on white-collar investigation and prosecution. So at a speech in the fall, Principal Associate Deputy Attorney General John Carlin announced that there would be a surge of resources for white-collar enforcement. And as one example, he said that there would be a new FBI squad embedded in the criminal division's fraud section at Main Justice that would focus on supporting the fraud section's FCPA and securities and other financial fraud investigations, and would focus in particular on data mining and data analytics. Last week, at this year's ABA White Collar Crime Conference, Attorney General Merrick Garland reinforced and underscored that surge and that investment of resources by announcing that they would be investing resources to hire 120 additional prosecutors who would focus on fraud, largely pandemic-related fraud, but other kinds of fraud as well. And they would hire 900 new FBI agents to focus exclusively on white-collar crime. And then at the same speech, he also announced in the wake of Russia's aggression in Ukraine and the US response that there would be set up a devoted task force called, I think, Klepto Capture that would be focused solely on pursuing illicit Russian money through money laundering and other corruption-related investigations. So in combination, the US's strategy on countering anti-corruption, Deputy Attorney General Monaco's pronouncement in October, and the various pronouncements about increased and surging resources have the effect of increasing the likelihood of corporate enforcement for individual companies and increasing the costliness, the intrusiveness, and the burden of undergoing them. And thank you very much. I'll turn it over now to the next panelist.
Thank you.
Gina.
Thank you, Jason. As Larry said, my name is Gina Poliveccio. I'm a partner in the White Collar Defense and Investigations practice in the New York office of Mayor Brown. And prior to joining Mayor Brown, I was in an AUSA in the Eastern District of New York for over 11 years, where most recently I was the chief of the International Narcotics and Money Laundering section, where much of my practice focused on international money laundering investigations and investigations of institutions for Bank Secrecy Act violations. So today I'm going to talk about the number of ways where the Biden administration has signaled that it intends to use anti-money laundering tools to pursue its priority of fighting global corruption. But this is really nothing new for DOJ. We've seen over the last several years a number of ways in which DOJ has used money laundering prosecutions as a method to pursue corruption-related conduct when a foreign official or another actor cannot be directly charged under the FCPA or other anti-bribery statutes. Now, DOJ has used this strategy against a broad array of actors, including foreign officials, their family members, bank executives, and institutions themselves. And the reason why money laundering charges are a favorite tool for DOJ is that it allows DOJ to prosecute foreign government officials who allegedly receive bribe payments, even when DOJ cannot satisfy the FCPA specific jurisdictional or evidentiary hurdles. And it's also, the money laundering charges also have a great deal of flexibility, which is, again, why DOJ has availed themselves of those statutes in a variety of different corruption prosecutions. Money laundering charges are predicated on underlying violations of specified unlawful activity, which lists a whole host of different crimes. So their reach can extend to violations of a variety of different crimes, as well as non-US bribery laws. So I've listed here some recent examples of cases that DOJ has pursued, corruption cases DOJ has pursued using the anti-money laundering statutes. For example, there are the Odebrecht-related money laundering cases that are out of the Eastern District of New York, in which prosecutors targeted a series of bank executives and family members of foreign officials who are alleged to have laundered funds through the US banking system using a series of shell companies that were then, and the funds laundered through those mechanisms were used by Odebrecht to pay bribes. There is also a series of what's known as the Venezuela state corruption cases out of the Southern District of Florida. And that involved a series of prosecutions targeting individuals who allegedly participated in bribery schemes to secure Venezuelan government contracts under the Maduro regime, and which allegedly allowed Maduro to profit from government contracts. There have been a number of individuals that the Southern District of Florida have targeted using money laundering statutes. And finally, the example that Larry mentioned at the outset of this presentation, there were a series of FIFA money laundering cases that came out of the Eastern District of New York as well. And there, prosecutors brought a series of actions against financial institutions that were deemed to have been complicit in assisting soccer officials in laundering their ill-gotten bribe money. May I have the next slide, please? So how will the Biden administration approach this? As Jason mentioned, the administration appears intent on continuing this trend of using AML prosecutions to target corruption. And as Jason noted, the US strategy on countering corruption specifically highlighted curbing illicit finance as one of the principal ways in which it intends to fight corruption. So how will it do that? The strategy seeks to follow the money to root out corruption and kleptocracy in three principal ways. First, by improving transparency in financial transactions. Second, by increasing obligations of gatekeepers to the financial system. And third, by strengthening international collaboration in anti-money laundering investigations and granting new powers to law enforcement that will act as a force multiplier for anti-money laundering enforcement efforts in the US and abroad. And these steps are really a cause for concern, in particular for financial institutions and other corporations operating on a global scale, because it really creates secondary liability for those who may unwittingly be doing business with kleptocrats or actors paying bribes. So as Jason mentioned, it augurs a great deal of increased compliance requirements and just general risk. Now let's first talk about transparency. The administration's push to improve transparency is addressed in part by the new beneficial ownership registry that was established pursuant to the National Defense Authorization Act that Congress passed at the beginning of 2021. The registry, which will be maintained by FinCEN, is intended to provide a single comprehensive source of beneficial information to prevent bad actors from forming opaque legal entities like shell companies to further their financial crimes. This registry will be an especially important tool in law enforcement's toolbox in their follow the money objective and corruption investigations. Now, this will apply to US entities and foreign entities that are registered in the US, including limited liability companies. And it requires that companies must register with FinCEN and report to FinCEN all ultimate beneficial owners, which means all individuals with substantial control or a 25% ownership interest, all company applicants, and the reporting company itself. Now, there are some exemptions to the registry, and it generally includes entities that are in heavily regulated industries, such as US banks, SEC reporting issuers, broker-dealers, and registered investment companies and advisors. Now, another way the administration seeks to achieve greater transparency is by ramping up reporting requirements on real estate transactions. High-value real estate has long been a favored vehicle to shield corrupt actors' assets. And in recognizing that fact, the administration is pursuing enhanced regulations to prevent bad actors from exploiting real estate for money laundering purposes. Now, FinCEN had already implemented a reporting program back in 2016, but the geographical scope of that program is quite limited. And recent statements by FinCEN indicate that it will seek to expand that program nationally. Any enhanced regulations in that regard will largely fall on real estate professionals and parties involved in real estate transactions, and they'll be the entities that are required, will fall under the burden of that greater reporting. May I have the next slide, please? Now, continuing on this theme of new AML reporting requirements for gatekeepers, as part of the strategy to counter corruption, the administration will also seek to increase reporting obligations of a broad array of gatekeepers to the financial system, such as lawyers, accountants, and trust and company service providers. Historically, law enforcement has had difficulty holding these gatekeepers accountable for facilitating transactions that mask illicit funds, because the regulations and laws didn't really require gatekeepers to have an understanding of the nature and source of their clients' funds. But the strategy seeks to change that. One example that the strategy gives is that it indicates that the Treasury Department will re-examine anti-money laundering requirements for investment advisors such as hedge funds and private equity funds. So that is a trend to watch. Another prominent feature of the strategy's follow the money component is increased coordination between the US and its partner countries. As Jason mentioned, we anticipate a lot more international coordination between the US and its partner countries in prosecutions of corruption, and also focusing on this money laundering strategy. Now, this will largely be accomplished through new tools established under the Anti-Money Laundering Act, which was passed as part of the NDAA. It will allow greater sharing of suspicious activity reports with foreign partners. It will involve sending envoys to work with foreign partners to strengthen their anti-money laundering regimes. And it will give federal prosecutors enhanced subpoena power to reach foreign banks and foreign bank account information. Developments under the AMLA will also empower the DOJ and the Treasury Department to seek forfeiture and recovery of stolen assets. And that meaning funds traceable to foreign government corruption that are held at US financial institutions and found in the US or in the possession of US persons. That will largely be accomplished through two programs: the Kleptocracy Asset Recovery Initiative and the Kleptocracy Asset Recovery Rewards Program, which is a whistleblower program which encourages individuals to report to the Treasury Department or DOJ about funds that are linked to kleptocracy that are held in the US. These programs will become all the more important with DOJ's recent announcement about the Klepto Capture Task Force, which Jason mentioned, that interagency task force that's aimed at restraining the finances of Russian oligarchs. That most certainly will involve anti-money laundering enforcement. May I have the next slide, please? Now, as I mentioned, the new AMLA legislation created enhanced subpoena power for federal prosecutors, which allows them to greater latitude to obtain information about foreign bank accounts, so long as it involves a foreign bank with a correspondent account in the United States. So this really significantly expands US government's ability to subpoena account records of non-US banks. Now, prior to this legislation, federal prosecutors or the Treasury Department could subpoena records relating to a U.S. correspondent account of a non-U.S. bank, but it could only relate to that correspondent account. Under this new provision, Section 6308, subpoenas may include records relating to the correspondent account or any account at the foreign bank, including records maintained outside of the United States. Subpoenas can be issued in connection with an investigation of any violation of U.S. criminal law, a civil forfeiture action, or the Bank Secrecy Act. Now, a non-U.S. bank served with subpoena may petition a U.S. federal court to quash or modify, but asserting that compliance with a subpoena would conflict with a foreign secrecy or confidentiality law cannot be the sole basis for quashing or modifying a subpoena. So this really exposes bank records maintained abroad to U.S. subpoenas as long as prosecutors can connect a potential violation of U.S. law to a customer or employee of a non-U.S. bank that maintains a U.S. correspondent account, even if the allegations do not directly involve transactions related to the correspondent account in the U.S. It's really sweeping authority, and it eliminates the need for prosecutors to engage in the mutual legal assistance treaty process, which is an extra step prosecutors had to go through that frankly allowed financial institutions some extra time to determine how they would handle such requests. It's also a tremendous tool for investigators who are doing cross-border corruption and anti-money laundering investigations, and will undoubtedly help support the surge in enforcement that we anticipate. And with that, I will turn it over to Nicolette, who will discuss anti-corruption enforcement in Europe.
Hi everyone. Thank you, Gina. Thank you, Jason as well, and a huge thank you, Larry, for being our director of the whole orchestra here, talking about the world. My name is Nicolette. I am a partner in the Paris office. I've been practicing this area for 23 years this year. I'm originally Canadian. I've worked in Washington, D.C., in Montreal, in London, in Sydney, and now in Paris for many years. I'm a former regulator as well, spent half of my career as the Chief of Staff of the Canadian Securities Commission. I have been a general counsel. So I've had a chance to see the evolution of investigations, of compliance, of enforcement from very interesting angles and at interesting times. So I'll have the pleasure to briefly give you an overview of what's happening in Europe, continental Europe, obviously, and we'll have a few seconds as well about the UK and how the UK is fitting in all of that. But what we have seen in Europe is drastic. We've seen very important changes. You know, Jason you were referring to the OECD and all that evolution through many years. So when you just look at the 10 years, but it's even more the last 5 years, the changes in terms of one, legislation enforcement, stronger legislation, two, the actual enforcement and new regulators, new authorities, and stronger powers to those that are existing, and three, the reinforced cooperation, both on, of course, the international cross-border level, whether it's within Europe or with third countries outside of Europe, such as the US, but also many other countries, but also across sectors. So regulators have signed many cooperation agreements, sharing of information agreements, whether it's with the antitrust agency in France, if you give France as an example, because that's where I sit, or whether it is with financial regulators, anti-corruption regulators, data privacy regulators. So there's a big sharing of information, and we'll see through my brief presentation how that evolves into actual examples of enforcement that you've probably all followed on a global scale as well. I'll say one of the interesting aspects, and my brief presentation, we don't have much time, but I will try to both talk about AML and ABC because we've seen strong changes in both of these areas. So in terms of AML, for those that are in Europe or have followed regulatory changes in Europe, in AML, we always talk about AML directives. We're now at the latest three. We still talk about the latest three, the fourth, the fifth, and the sixth AML directives, which are transposed locally into European countries. And obviously the transposition is always the minimum standard that needs to be transposed. That's how European directive works. European regulation is word to word the same text. The directive is what is transposed at a minimum. Of course, countries in Europe could go further, but that's the minimum standard. But yet it's a rather harsh, I would say, high level standard. And in France, it has been, of course, transposed into the monetary code, as you can see on the next slide. So maybe could somebody please just change slides? Yes, perfect. So as you see, what's interesting is France actually goes the furthest, I would say, in Europe on many aspects. That's why we use France as an example as well, mostly because it has higher mandatory concrete obligations that are codified in terms of prevention. And we'll see how that basically relates in terms of just general risk assessments on KYC. And this is seen mostly in the corruption legislative framework, but we'll see also how on the AML framework this has been reinforced. Next slide, please. So here the FAP recommendations, as you know, are basically, it's an intergovernmental body, of course, that has issued its 40 recommendations and that is constantly working as well on trying to coordinate on a global level the level playing field in terms of anti-money laundering and financing of terrorism, trying to find also those minimum standards, because it's still, I think, us as lawyers and jurists, it's still on an international scale, it's still a challenge, because sometimes we talk about corruption, but corruption is not necessarily defined the same way in different countries. And so it's the same thing for money laundering. So it's interesting to see how there's a strengthening between states now to do that. Next slide, please. So the difference between the three money laundering directives is interesting. So the fourth basically reinforced the obligation, and Gina, you were talking about beneficial owners, reinforcing basically the transparency in terms of beneficial owners. And there's also a new development in Europe to create a register of beneficial owners that first of all will have to be done on a national level and then on a European level. And of course, the idea is also to simplify further KYC and due diligence so that you go to one source where everything is identified. And we'll see more or less how that's going to work, maybe not work, but that's an objective that is really there to simplify the transparency of beneficial owners. And again, another challenge, different jurisdictions have different thresholds what a beneficial owner is, from 5, 10%, 25%, an ultimate beneficial owner. So that's another challenge that we're really seeing on the international scale. The fifth money laundering directive, if you just go back quickly on the previous slide, what's interesting is the enhanced measures have been strengthened. Basically, the consequences relating to high-risk third countries, they have been better defined and better clarified. And of course, virtual currencies risks have been introduced in the fifth one. And the sixth one is an interesting one because it proposes the criminalization of money laundering. And again, creating a playing field on the definition of what money laundering is in Europe across nations, and imposing a minimum of 4-year prison sentence. So that's also pretty new and pretty strong in terms of qualifying that type of offense. Next slide, please. So on this slide, you have examples of some of the regulatory bodies that are operating across Europe. The first one that has been talked a lot about lately is a new European public prosecutor. And it's interesting because it gives powers to go cross-border, because as we all know, and that's the purpose of the seminar today as well, these type of offenses, they're not limited through one border, right? And you see Jason's at the other end of the world today. But, and that was one of the challenges for prosecutors in Europe. You had a problem in France and a problem in Germany. You had to go to the German prosecutor. They had to organize the subpoenas. Gina, you're talking about the whole process in the US. Well, here you had basically, and because you've worked in France and in Europe as well. Yes, here the idea is to have a European prosecutor, more or less, I would say, limited in terms of its reach and its parameters right now, because it's only for crimes that are against basically the financial interests of the union. So you might think about tax, for example. The idea is to see if this will expand to other areas, other types of offenses as well. So of course, it's cross-border. and it began operating in 2020. There are still some technical issues, administrative issues going through, but that should be a big difference in terms of the immense strengthening of enforcement in Europe. Then, of course, you have a proposed authority for money laundering on a European scale for 2023, which would have group-wide prevention, so compliance, and the actual work with the national regulators to be transparent on how they operate. And of course, you have all the existing bodies for securities, ESMA, the European Securities Market Authority, pensions authorities, the banking authority on the European level that are also strengthening their powers because they had a very strong role until now in terms of guidances, in terms of regulatory standards, and so on and so forth. But now they're really strengthening also their powers more and more. And of course, in France, the creation of the new anti-corruption agency that we'll talk about it in a minute. Next slide, please. So in France, so Loi Sapin, I think all my colleagues on the call know, because they've heard me talk about it a lot, is drastic. It codifies the obligation to have an ABC, an anti-corruption preventive program, independently of any corruption allegations, independently of any, I'm thinking of the failure to prevent of Article 9 of the UKBA aspect. It's not a guidance, so it's in the law. And there's also a regulator that has issued very, very specific, detailed guidances on how those preventive measures have to put in place. So we have very little independence or very little play to apply them, more or less. It applies to every French company, headquartered French company above that has at least 500 employees and 100 million in annual turnover, or to any international non-French headquartered company that has activities in France that falls under these thresholds. And what's interesting is the reach, because we're talking about around 3,000 or 4,000 companies in France, and now we're talking about hundreds of thousands of companies that would fall on it if you take that international aspect. And that's what we say France has now an extraterritorial application of preventive AML law, if I may say. And it also creates in this law, the Loi Sapin law, it also creates a new agency, the AFA, the Agence Française Anticorruption, which is the French anti-corruption agency that has, that is an interesting animal. It has, so it's not a prosecutor. It's not a fully independent administrative agency. It's an agency that falls under the Ministry of Finance with powers, with two objectives: one, to educate, and two, to audit entities and issue recommendations, and then it can always bring it to its sanctions commission if the recommendations are being covered. And of course, what's interesting as well, important strengthening, and that's not only in France, but also on the European level and European scale, the strengthening of whistleblowers protections. So that's not only in terms of how the whistleblowing should be dealt with by the company, who can be the whistleblower, internal, external, do they have to be anonymous or not, and what kind of protections are issued, what kind of information you have to give them, and how guidances as well. The AFA just yesterday published for consultation a document, a guidance on internal investigations, whether they come through whistleblowing or not. So that's also a big change. We're not yet close to what we see in the US with financial regulators in terms of awards. It's still an important change of mentality and culture in France. We've seen it over the past 4 years, with 5 years almost now with the Loi Sapin. But these changes into incorporating whistleblowing on a larger scale, not only in the financial aspect, is a big change. Next slide, please. So here, you have a summary here. Of course, we won't go into details, but here on the left side, you have the 8 Loi Sapin measures. So from having a code of conduct that is, again, specific to the guidance issued by the regulator, an anti-corruption, obviously, code of conduct, whistleblowing system that respects different decrees on how it has to be put in place, the protections, of course, of whistleblowers, a specific risk mapping that basically calculates the risk based on different tools and different information, different kinds of interviews that are also expected by the regulator, and then more or less calculates that risk based on different elements as well, and an annual kind of review of that risk mapping. Third-party due diligence, obviously KYC of any third party, clients, suppliers, employees, any kind of third party you can imagine, with very strict suggestions from the regulator, again, because it's a guidance on how to do it, even though in the law, here it's the law that it has to be done, and then the way it's done is through that guidance. Of course, strengthening accounting procedures to make sure that corruption cannot be hidden through accounting procedures, anti-corruption training in a specific way as well, a disciplinary regime, so to have clear sanctions for the non-respect of an anti-corruption code of conduct and all the policies that relate to that, whether it's gift and entertainment, whether it's due diligence of third parties and onboarding of new, agents that you might have, business development agents, and so on and so forth. And finally, to have a clear way of controlling and auditing your compliance program. Next slide, please. So you see, those are measures that I would say have been intense and heavy resource-wise and energy-wise for many French and international companies that have to deal with that. There are sanctions that are related to that. In summary, what you have here are the sanctions for the acts of corruption, and underneath you have the sanctions for the lack of or the weakness of a preventive system for corruption. But for example, what's interesting, France sanctions private corruption, public corruption, active corruption, passive corruption, public corruption, and private corruption. So all of these are part of the criminal code in France, which is also a big difference, I would say, with different definitions around the world. And we've worked closely with the B20, for example, discussing and realizing how different it is from one country and another. When people talk about, corruption offenses, it's not exactly the same all the time. So strengthening of these sanctions, and of course, sanctions from the regulator that include, of course, monitoring, that can include indirectly imprisonment for example, not respecting the confidentiality of a whistleblowing system. And so on and so forth. So next slide, please. So very briefly here, the AFA director, which is more or less the head, the chair of the French anti-corruption agency, has a lot of powers to audit, give warnings, or injunctions if they're not respected. There's a sanctions commission that he can go to. He more or less also may refer, like any public body in France, to the financial prosecutor, any criminal offense he might see, whether it's money laundering or corruption through an audit. Next slide, please. So because we've been working with many entities around the world on these issues, what's interesting as well in France is the liability of having a preventive system to fight corruption falls on not necessarily the company, but actually the management on a personal level. So it's presidents, boards of directors, so executive and non-executive, so as well as the management, the executive management. So it's not the chief compliance officer, it's not necessarily the company, which would be as well as a legal person, but also individuals. And this is, I think, also a clear message from the legislator on empowering the tone from the top and empowering them into taking action and putting an efficient system in place and having a tolerance zero, more or less, an approach. So this is an important change as well. Next slide, please. So more or less, one of these last slides is an interesting introduction in France as well, is what they call in France negotiated justice, is with you in the US and the UK and many other countries have had for many years, is a DPA or an NPA, because more or less in France, I would say it's maybe a little bit closer to a non-prosecution agreement. And it's so in just 4 years now, the Loi Sapin exists since 2017. We've had almost 20 signed French equivalent DPAs, which is, when you look statistically, an immense number when you compare it to other countries. So basically the French prosecutor, it's always at the invitation of the French prosecutor, can suggest a negotiation. Of course, it's called a CJIP in French. So Convention Judiciaire d'Intérêt Public. So more or less, it is limited to certain areas, whether it's corruption, whether it's tax, whether it's money laundering, fraud. They have added new areas lately, such as environment, and it has been used very much. Two examples that I think to conclude, I think on this whole section is for those that have followed international cooperation, is of course public sanctions, such as for Airbus, with almost $3 billion that was more or less shared between three regulators, of course, the UK, the US, and France. So they really worked hand in hand in terms of exchanging information, in terms of enforcement, but as well in terms of sharing the fines at the end. Or Société Générale, which officially was sanctioned for 500 million, 250 went to the US, 250 went to France, even though France claims that they did most of the work. But that's an interesting example of how they're basically working hand on hand on a global level, regulators and prosecutors, mostly here in Europe, but mostly as well with their international counterparts outside of Europe. Thank you very much, and I'll leave it to Michel, I think.
Thanks, Nicolette. Hi, everyone. As Larry introduced me at the beginning, I'm Michel Sienkovsky. I'm a partner in our São Paulo office and a co-head of our global white-collar defense and compliance group. I mainly work with internal investigations, cooperation and settlements with Brazilian, and I have experience also with US authorities. And because of my Argentinian background, I'm also fluent in Spanish and have been working on several cases in Latin America, particularly in Argentina, Colombia, and Mexico. So today, I will provide here a quick overview on, there you go. A quick overview and analysis on the anti-corruption and enforcement in Brazil, particularly on how the Monaco memo and other initiatives from the US government should impact Brazilian companies. And I would like here to stop and look back to the last 10 to 12 years, and we will see an interesting phenomenon in terms of enforcement in Brazil. So if we go back to 2013, and it was enacted our Brazilian anti-corruption law, which came into force 6 months later in January 2014. And as many of you may know, this law stipulates in what way and to what extent legal entities may be placed under administrative or civil responsibility for corruption and other acts considered detrimental to national and foreign public administration. And this law has a broad scope and includes not only corruption, but also fraud in bidding processes or bid riggings, for example. And in the same period of time, and a couple of months later, that important law came into force, the well-known Operation Lava Jato was launched. And looking back and analyzing the enforcement in the period, we can notice, let's say, like a boundary, the year of 2014. So before 2014, the flow in terms of enforcement was usually through US authorities toward Brazilian companies based on the extraterritoriality of the FCPA. And there are a couple of cases and settlements with Brazilian companies which started before or during 2014. And the trigger was from the triggers were from US authorities sending subpoenas, for example, for local companies. And the fact is that from 2014 on, with the launching of Operation Lava Jato, the enforcement in Brazil from local authorities became higher and higher. And just to illustrate here, from 2013 to 14, in 1 year, the operations launched by the federal police in Brazil increased at around 30%. And from 2014 to 15, the increase was an additional of 32%. So in 2 years, we had also 62% on an increase of operations from the federal police, which made clear that it was an increase in enforcement in Brazil. And in addition to that, Brazilian authorities have shown to be great cooperators with US authorities. So with all that together, suddenly we saw a switch on the flow very recently. So the enforcement in Brazil was higher. A lot of Brazilian companies subject to the FCPA and Brazilian and US authorities keeping a high level of cooperation and working together on several cases. And just to provide you, when we mention about that international cooperation, just an additional data here, under Operation Lava Jato, according to public data released by federal prosecutors in Brazil, there were over 700 requests of formal international cooperation, not considering only those informal, as we all know that they were in frequent contact. And this scenario, of high enforcement continued until February of last year, when the Lava Jato task force was dismantled and became part of the GAECO. So from that moment on, together with several political events that certainly, just move here. So political events that certainly impacted the enforcement in the country, we started to see a reduction on the enforcement, particularly from the federal prosecutors who historically were the leading figures in those cases. So the numbers of operations started to reduce, as well as new cases in the media. But on the other hand, we started to see an increase on the enforcement from other authorities in Brazil, not only the federal prosecutors. I would say mainly the CGU, our Controller General, who is the entity with powers to enforce our anti-corruption law in the federal level, the TCU, our Court of Accounts. And it was very interesting to see our Brazilian SEC approaching individuals behind the corruption schemes. As the Yates memo, as we saw in the past, US authorities with a great focus on individuals, we started to see those individuals being charged by the Brazilian SEC. And we noticed that because several of our clients, mainly legal entities, started to receive subpoenas from the Brazilian SEC asking for information about the allegation and involvement of those individuals in the schemes. And even after the remediation process, when those individuals, in many cases, were no longer with the company. And we also saw some individuals being charged by the Brazilian SEC for violation of their fiduciary duties. So despite the reduction on the enforcement from Brazilian authorities, one of the things that came to stay in Brazil, and I think mainly after Lava Jato, is the importance of creating and maintaining an integrity and compliance corporate environment. This continued to be one of the top items in the agenda of Brazilian companies, and I would say became a requirement from the market as well. It is very common to see companies not doing business with other companies who does not have a compliance program, and the concern with compliance issues during, for example, M&A transactions or even IPOs. So apart from that, we also saw a pressure from the OECD monitoring and also emphasizing the setbacks in Brazilian enforcement together with the Transparency International. With all that scenario that we see, in one hand, Brazilian prosecutors, decreasing the enforcement, we also see an increase from other authorities and also an increase in settlements with Brazilian authorities. Not only leniency agreement, but also plea bargain agreements and a new figure that is the civil non-prosecution agreements with it is under a different law, but also a kind of settlement that we have seen an increase in the last months. So looking forward, and based on the Monaco memo and what my colleagues just described it, we should expect to resume the scenario before 2014 in Brazil, where anti-corruption enforcement in Brazil usually occurred through US or international actions toward Brazilian companies because of extraterritoriality of the FCPA, a focus in Latin America, and also international cooperation. Here, this is self-explanatory and we are running out of time. I will skip very quick here because you guys will receive this presentation, this slide deck afterwards. But basically, this shows, the numbers of leniency agreement with the CGU in the last years, and also the amount overall the payment agreed with local companies. Here is a chart that would show all the companies, and in total 15.5 billion for non-Brazilians. Just divide that number by 5 and you get it in the amount in US dollars. And here the amount per company. Here is a slide deck with is a slide with the number of leniency agreements over the years. So we saw an increase, of course, in 2020, a reduction possibly because of the COVID pandemic, and then that number of leniency agreement resumed last year. And here, 2 case studies just to illustrate that very recently the global negotiation continues to be a focus, particularly with Brazilian authorities. We have one case here, the US and Brazilian authorities to settle alleged crimes still related to contracts with Petrobras. This started to happen since 2014. And another case that would include not only MPF, but also the US and British authorities. Thank you so much. Very brief and quick overview about Brazil. I will pass to Larry.
Hi, hello, everybody. We're going to be discussing monitorships and DOJ's policy, and given the time, I'd like to do it in an expedited way. The bottom line is that the Biden administration has come out with a position with respect to monitorships, which is not fully formulated, but generally makes the ability to get a monitorship somewhat more difficult. We have the next slide, please. And what we know about it for sure is we know what it's not. And what it's not is reflected on the screen. There was a memorandum by the Assistant Attorney General in the Criminal Division, Sienkovsky, on October 11, 2018, which set forth a policy. Next slide, please. Next slide, please. Next slide, please. Thank you. And I'm skipping through it because I'd like to get to the nub of the issue. This is the portion in the Sienkovsky memo that is rescinded by the Department of Justice. And what the Sienkovsky memo said is that, in general, the criminal division should favor the imposition of a monitor only when there is a demonstrated need for the clear benefit to be derived, a monitorship relative to the projected costs and burden. Where a corporation's compliance program and controls are demonstrated to be effective and appropriately resourced at the time of resolution, a monitor will likely not be necessary. And another point in the Sienkovsky memo underscored is that a monitorship is not meant to be punitive. Essentially, it's based upon present responsibility. And this policy, when it came out, was greeted with jubilation by the defense bar and corporations, because it essentially casts the burden back on the prosecutor to demonstrate, in the first instance, is the monitorship worth its cost? Next slide, please. And what the Monaco memo says rescinds the Sienkovsky memo to the extent that I just read it. And it says, in recent years, some have suggested that monitors would be the exception, not the rule, to the extent that prior Justice Department guidance suggested that monitorships are disfavored or are the exception. I am rescinding that policy. What's she rescinding? She rescinded what's on the prior page. And then she says, instead, the department is free to require the imposition of an independent monitor whenever it is appropriate to do so, to satisfy the prosecutors that the company is living up to its responsibilities. Next slide, please. And then following that, there's another document that's put forward by the Deputy Attorney General and cited here, which indicates that costs can be considered as a factor. And I think the bottom line on this is that the Department of Justice's position is that there's no default presumption against a corporate monitor based upon cost, that the cost-benefit analysis does not apply. Next slide, please. So what do you do? How much does it change the calculus with respect to monitorships? And I will, given time, advance the bottom line. It's my view that a monitorship can still be avoided, and the odds of doing that depend completely on the implementation of several steps, which I invite your attention to at your leisure in the following slides. And it essentially says to speak to the government through their own language. There is a June 2020 definition of a compliance program. And the interesting part of it is that it's a rare instance in which the government is not speaking to the regulated industry, but it directs the prosecutors to answer the following questions. Is the corporation's compliance program well designed? Is the program being applied earnestly and in good faith? In other words, is it adequately resourced and empowered? And does the corporation's compliance program work in practice? It's a practical matter. And stepping forward, our approach has been to take those points, speak to the government and say, this is your standard and we've met it. And to empower the prosecutors that we're talking to at the line level to speak to their supervisors and say, here are the questions we're asked and here are the answers. And as we step forward to the next slide, here are other questions that standard questions you should be prepared to respond to. Next slide. The process that's recommended enlists the compliance constituency in the company's advocacy. What do I mean by that? Monaco said that the decision with respect to a monitor depends upon trust. What you want them to do is to trust the compliance constituency in the company, and they should be visible and step forward in the presentations and the like. Be prepared to cite prior resolutions. Do you ever see a case that comes out and there's no monitor and you wonder how that happened? Look at this and that. I think that stands for the proposition that monitorship decisions are based upon present responsibility at the time of resolution, not the past. And that leads to the point that no matter how bad the situation factually may be, if you fixed it, it's fixed and it's not punitive, and benchmarks help you make that argument. The step 5 is testing and compliance. What the government is focused on tremendously is metrics. They don't want you to tell them what you're doing. They want you to demonstrate it, as we were told by the head of the program in the government. I don't want you to tell me I have a cake. I want you to cut me a piece and I want to taste it. I want to see it, and that means analytics. The next slide, please. I think that we're over time, and that's where we are. If you have questions that are set forth, you can send them to us, and we'd be happy to respond to them. Thank you very much for your kind attention. It was our pleasure to present to you today. This wraps up the program on behalf of Mayor Brown and my colleagues. We hope you found it interesting. As a final housekeeping, I'd note that a recording and link to the materials from this program will be distributed by email to you in the next day or two. For those applying for CLE credit, please note that the certificates of attendance will be distributed within 30 days of the program date. Thank you for participating in our program. This concludes our website, and thanks again.